where our goal is to inform and educate our listeners on matters related to finance, legal, insurance, accounting, and other interests that are of personal and business.
The Expert Network team consists of Karl Frank of A&I Financial, Mike Miller of Miller and Associates CPAs, Jeff Cromendike of Security First Insurance.
Together, our independent team combines our expertise to provide you insights and solutions, some straightforward, some profound. We hope you enjoy the information contained in today's podcast and find it useful. If you'd like to learn more or desire to meet with any of the Expert Network team members in person, you can contact us at info@expertnetworkteam.com. That's INFO.
We encourage you to take advantage of a free consultation with any of our team members. Just mention this podcast when you schedule your appointment.
Hello, everybody. Welcome to today's podcast. I'm Karl Frank with A&I Financial Services, and with me today I've got Nathan Merrill with Goodspeed Merrill. Hello, Nate.
Hello there.
And we've got John Sauer also with Goodspeed Merrill. John's Goodspeed.
It's a great law firm.
It's a great law firm, and John is a great lawyer with employment law. How are you, John?
One of our best.
I'm doing great. So thank you so much for having me again.
I'm so glad to see you again. And we're excited to talk about enforcing non-competes. So in our recent podcast, we discussed
the breaking news.
The breaking news about new law changes for Colorado employers and employees. And the non-compete rules got a lot weaker for the employer and a lot stronger for labor. And today we're going to talk about how to enforce that and what enforcement looks like from an employer's point of view. Did I summarize that pretty well?
I think so. And just to recap, I don't know that we concluded they necessarily got weaker, but they got more technical or more specific.
Yeah, you have to have technical compliance.
Yeah. So taking that technical compliance further, I think we can rule out technical non-compliance. If you don't have a compliant non-compete, there's not going to be any point. I mean, what value is it worth anything more than the paper it's printed on at that point, John?
So this is kind of when you get back to the criminal penalties issue. So, there's obviously professional rules of conduct that you can't threaten criminal sanctions against another attorney, but I have seen it occur where an employer tries to enforce a non-compete, and in response to that, they get a notification from the employee's attorney that the non-compete is unenforceable, and your efforts to enforce it would be a violation of,
Sometimes that's
Title
very
18.
subjective, though, and they're just bloviating, correct?
Exactly, but there's
now
no
with
threat.
these more technical requirements, if you have a facially non-compliant situation where there's no factual question, they did not initial the notice page.
Yeah.
You're saying that as an attorney, you would be, I don't know if remiss is the right way or whatever the word is to say, you should not advance that down the field.
You should not, if you know that it's not compliant, you should not try to enforce it. That's correct.
Okay. So it isn't worth, if it's non-compliant agreement, now there's really no strategy to try to bend the will of the employee. You just simply have a worthless piece of paper.
That tool in your toolbox is no longer there.
Okay.
Right? So there's other ways to go after an employee.
Well said, counsel. Counselor. So let's now move on to where you have something that at least appears on its face to be valid, or is, well, let's start there. So I think we all know that in the practice of law, not everything is definite. Well, why don't we talk about kind of the initial steps of evaluating whether someone might consider enforcing or have an enforceable agreement?
So there's always a concern about what the tenor of the situation is, right? Is this an emergency? Have they taken the crown jewels and you need to shut this down immediately? Or is this, they've got in their Rolodex a couple of your clients and you're concerned that they may call them. You need to send a demand letter soon, but it's not, set the world on fire, shut it down. So from my perspective, starting with the presumption that we've done an evaluation of the enforceability of the agreement, we kind of do a decision tree, right, about what are our options here? How is the employee going to respond to this situation? Are they going to take a demand letter seriously? and
Stop,
or do we actually need to go
send
get
over
a
the
TRO?
sheriff. Right.
The nuclear bomb in these types of cases is you file a TRO, which is a temporary restraining order. You also typically sue the employer that's hired this person away.
Okay.
So that because more likely than not, they're not only in receipt of misappropriated trade secrets, they're probably aware of the non-compete, and
So
may have been
is that-
acting in cahoots with the
Is there
employee.
such thing as aiding and abetting a breach of contract, or is that
It's effectively a tortious interference.
Gotcha.
claim.
Gotcha. Okay.
What does that mean?
So, a tortious interference with contract claim is when, in our scenario, the new employer, where the employee that's leaving is taking the crown jewels, they're taking the crown jewels over to the new employer. The new employer, if they have notice and knowledge of the non-compete and notice of knowledge of these trade secrets, I mean, there's several types of claims you can bring, but the primary one is tortious interference with contract, because they're aware of the agreement that you have with the employee not to go compete against them.
Got it. So that requires that you prove that the new employer knows about the contract?
Yes.
Or knows that they're getting protected information. Oftentimes or occasionally, the person might be being hired specifically because they have access to that information.
Got it.
And those cases are the fastest moving cases in litigation. So for a TRO, you typically...
They talk about TRO and kind of what's involved there.
So a temporary restraining order is a request for an emergency order from the court to issue basically a protective order to prevent particular activities from occurring. Under certain circumstances, a court will issue a TRO ex parte, which is in litigation somewhat unheard of. Like in my litigation cases, I can't just call up the judge and talk to the judge unless the other party is there. I can't do that. That would be improper ex parte communication. But under some circumstances, a court will enter an order preventing someone from doing something or engaging in a particular activity.
Aren't there like thresholds you have to meet, like irreparable harm, or what are those?
So you have to hit irreparable harm. You have to explain the nature of the emergency. Most of the time, you have to be able to prove that you gave the other side notice. You have to prove that the basis for the request is to preserve the status quo, effectively.
And no other available effective remedy or something like that?
No other available remedies at law.
Yeah. Boy, that digs way back. See, I'm a tax attorney. I don't do any of this stuff. That was like first year law school.
Are you
out.
showing off?
No, I'm just surprised. I'm patting myself on my back for
You're
myself.
getting, good feelings.
No,
Remembering
I've
those
actually been
professors.
through a couple TROs, but
Okay. But
So-
you get a hearing within 3 days typically,
yeah.
and that's fast. And
And how long do they last usually before you have to have a full hearing?
the TRO lasts 14 days.
Okay.
And then
Did you already say that?
No.
Okay.
You try to get a preliminary injunction typically with the TRO. A preliminary injunction is the same order, but it lasts through the pendency of the case.
Got it.
So in that way, it's similar to a criminal TRO, temporary restraining order against somebody if there were an abuse situation where
Yeah,
somebody
in
was
family law, you see them frequently.
right. I was thinking family law or any situation really.
Yeah,
where
I think
somebody
Johnny
might-
Depp had a TRO against
You ever heard from
Amber Heard.
Well, there you go.
Johnny Depp made TROs famous.
Is that
Famous
breaking-
Amos. What?
Is that breaking news?
Yeah, no, that's not breaking news.
I wouldn't even be able to tell you anything about that.
Those were fun to watch, though.
So
For
countercultural.
diversion. Okay, so now you're past the TRO. What's the next part of this enforcement process?
So let's talk about the TRO, how this works. You have to file the TRO document is somewhere between 10 and 20 pages of you laying out to the court why this TRO needs to be issued. You're setting the case up for a preliminary injunction. One of the other things you have to argue is likelihood of success on the merits. So the court would actually make an evaluation and make a determination based on a TRO outcome that you have a strong likelihood of success on the merits. If you get a TRO in one of these cases, the other side is immediately want to talk to you about settlement because you're going to win. The court's saying you're gonna
And
win.
just to reiterate, these are the crisis cases. The only case you'd bring for a TRO is where, like, you call it the crown jewels or something like that, where your business will be irreparably and irreversibly harmed
Yeah.
by exploitation of whatever the the situation is. So that's not every case. In terms of like how often you get involved in non-competes, how often, out of 100 cases, how many would be TRO type cases?
So I work on a non-compete issue every single day. I probably work on 10 different non-competes across a week. I mean, it's a lot of this is a big piece of my practice, a big piece of every employment.
Especially as the
practice.
workforce shrinks and shrinks and shrinks, is getting access to people who know how to do things is critical.
Exactly. And you really want to hang on to your people, and this becomes maybe a stick more than a carrot.
Right.
But, the TRO doesn't come up very regularly because
It's an extraordinary remedy.
It's an extraordinary remedy, and frankly, it's not that common that somebody will just take the crown jewels.
Because wouldn't a judge frequently or occasionally say, you have damages? I mean, it would really have to put you out of business for it to rise to the level of TRO. Otherwise, the judge would just say, just recover your damages and you'd be fine, right?
Yeah. Exactly, and I mean, the irreparable harm is you can no longer continue. It's like it's not damages; it's damages forever. They're incalculable, effectively.
So it seems pretty rare, less likely.
To go the TRO route, it's rare. I mean, it's fun as an attorney because it's like you suddenly
It's quick, dramatic, and you're done.
I feel like the
decisive.
Wild West.
It's very decisive.
So I mean,
John is much more deliberate than me.
I like it. In technology, I mean, famously, at least in my industry recently, and a lot of people are leaving Tesla to go to other companies. And so they're not going to be bringing, the Tesla battery with them, which might be that company's biggest, edge over their competitors. But if they go to Apple and they start up a car that works a lot like a Tesla, it seems like they're going to be bringing a lot of the confidential information. I can only imagine that the lawyers working for Tesla are going to be doing something to Apple. What does that look like?
So you can have one company sue another company, and I mean, it's effectively misappropriation of trade secrets. It's the same claim you'd bring against the employee that took the crown jewels, and you sue them, and this is when things get, I think, even more interesting from my perspective as an attorney, because you get to work with some really interesting experts. I work with expert opinions, people that provide expert opinions and research and all that stuff regularly in litigation matters, but the computer forensic examiners are it's somewhat incredible what they can pull out. And so, for instance, sometimes it's very hard to prove affirmatively that the trade based on what we can do with our weak understanding of Outlook or whatever, to see where the emails went or what was taken. I mean, a computer forensic examiner can see when a USB drive was plugged into a computer. It can identify different points in time as to when files moved to different folders, what was taken. So one of these cases I had, we started with believing that the person had taken the crown jewels. We got a computer forensic examiner to find out that they didn't just take the crown jewels, they took everything. They took a lot of stuff that they didn't even need. And that was all through the efforts of computer forensic examiner. And at that point, we got that person on the stand to testify about what had happened. It was very easy to win that case in a lot of ways because we had the right evidence.
Right.
So it's not just... Sometimes it's hard to prove, but I'm sure Tesla probably have 30 or 40 computers.
Yeah, they're going to have some brilliant men and women to do that job for them.
Yeah.
So what are some other? So if you don't have a crisis situation, you mentioned if you get a TRO, you're usually talking settlement pretty quickly. What does a non-TRO route usually look like in terms of the back and forth?
So the typical initiation is a demand letter, and I'll send demand letters. Sometimes I'll send a demand letter with a draft complaint, which is what you'd file in court if things didn't work. Frankly, it's honestly a good thing when the employee hires an attorney most of the time, because the attorney understands the gravity of the situation much better than the employee does. Mm-hmm. And then from the demand letter stage, what you're doing is you're laying out all the facts. You're not showing your whole hand, obviously, but you're laying out the facts as to what they took. And then you work through, either with the employee or with the attorney on the other side, typically a settlement agreement that includes return or destruction of what's been taken. There's always this issue of trust but verify, and that always becomes a problem with these types of cases, because especially if you're in a situation where the employer is convinced that the employee took something and they don't have it anymore, or it's been destroyed, you can't necessarily say that's been returned or destroyed. You get them to sign an affidavit to the effect that it has been destroyed, and then you have contractual damages or claims against them if you find out that they later have it or didn't destroy it. But under those circumstances, it's quite rare, I think, to hire like a computer examiner to determine that the documents have been destroyed. So in the emergency situation, when you do have the crown jewels, 100%, if you're going to enter into a settlement, you say, okay, we're hiring a third-party computer examiner. They are going to examine all of your devices to ensure that those files that you stole are gone. But on the lower level, you have to make kind of an educated decision as to whether this is
They could have
going to
other
be
devices,
affected.
or
Yeah.
their girlfriend could have a device.
Yeah.
I mean, how far do you go on those affidavits? Like, neither you nor anyone in your immediate family nor anyone who you had drinks with last Friday, or how broad do you have them attest that no one in their control or sphere of influence has the information?
Yeah, I think it's a good idea to have them broad, but you obviously you kind of get lengthy and it gets a little overzealous. But one of the things that can come up in these cases, and this is another thing to check the box when you're doing the initial client contact about these types of things, is and this is something that I've seen other lawyers get burned on. It's come up in my cases, unfortunately, but you send the demand letter and what comes back is, okay, fine, but you didn't pay me out my vacation leave, so we're going to file a wage complaint. I know that you discriminated against me because of these 7 reasons.
Make sure you've got all your ducks in a row.
It's not just, before you throw the bomb, you better know that you're bulletproof. So,
right. That's good. That's a good saying. Do you have that trademark?
No, not yet.
What was it again? For our listening audience?
Before you throw the bomb, you better know you're bulletproof.
Nice.
So, it's litigation is sometimes knock down, drag out boxing, and you want to win.
How long does a typical path go? How long does it take before an employer who begins this can expect to see an answer?
It's somewhat in my control as an attorney and somewhat not in my control, because I recently had a case that it was a silly settlement agreement and it took 3 months for some reason. I think that the other attorney was working an hour a week or something. I mean, it just never got back to me.
Right.
But I've had these things. I got one that I'm wrapping up right now. It's, 2 weeks.
Oh, that's nothing.
Yeah.
Yeah, so you can expect a fairly quick resolution. Even 3 months seems reasonable from my point of view, dealing with Nate. Things can take a while. It's the law.
What you mean by that?
I don't know anything, right? I mean, things take a while. So, but even a 3 month seems pretty quick.
Yeah, that's from the settlement perspective. And the emergency things, it can be even faster.
Faster.
Than the 2 weeks. So you can have if you have a hearing in 3 days, you show up, you put on your evidence, the judge will read the order from the bench, you win, and then you can have you have an order protecting you, and then you're immediately in settlement negotiations.
Is there a difference between, for effectively on timing or anything after this, for a non-solicitation of clients versus non-compete working for a competitor, on how long employers can expect to have to litigate these things on a typical path? Is there any difference between the type of case?
I think the thing that dictates the length of a case more than anything is the evidence. Right?
Is it?
And how much evidence you need to gather. So you have to go, the longest part of a case is the discovery phase. And so if you need a lot of evidence, you're going to tell the judge at the front end, we need 20 depositions, we need, 3 experts, we think that we're going to need expanded written discovery requests, whatever. And that can turn a case into a 2 or 3 year ordeal.
Okay, that's the type of thing. So it really doesn't matter the type of case. Because, the evidence for a non-solicitation seems pretty straightforward. The ex-employee either did or didn't contact or take an employee or a client.
And there's parts of these conversations with employers that want to enforce these that you really have to consider as to how litigation is going to play out, right? So if you have say your employee took the employee leaves, they try to take your biggest client, this person you've worked your entire career to originate, to
Right.
bring in, you're working with them, and now suddenly you're hiring an attorney to go depose your biggest client to figure out what their communications were with your employee that took off. That might make your biggest client quite uncomfortable.
Yeah, and never work with you again.
I was going to say, is with the bomb throwing and bulletproofing, is there still a situation where even if you win, you lose, and that could be it? It sounds like. Are there other tar pits that might be unsuspectingly?
So one thing I get concerned about, of course, is that there's a big movement towards having a positive work culture. And if you're known to go after your employees, you're setting a precedent. And whether that's a good precedent or a bad precedent is dependent upon, a lot of other factors. But, I don't want to, as an employee, I would not want to necessarily work for an employer that I'm going to leave and then get sued out of existence.
Right.
And the damages, we're talking about corporate level damages that these employees could cause. So you're talking about financial ruin potentially for the employee
Right.
if you put the pedal to the metal.
Because, yeah. That's
There's
true.
there's a reputational risk, isn't there? Okay, so let me flip the table, and now I'm an employer who's hiring somebody, and I get a letter from their former employer. Holy cow! Now what do I do? Right? Am I like, do I let this person go? How much at risk am I if they're going to start, especially if they're going to use some of these stronger language threats? I'm like, whoa! What did I just get myself into?
So I have employers ask me constantly, should I be asking employees about whether they have a non-compete or not? And ignorance is a defense in this situation. No, I didn't know they had a non-compete. You get them. But the reality is
to discover.
The reality is if you do no inquiry and the other side finds out that you have trade secrets or other protected information in your possession as a result of hiring this person, you're still wide open to a bunch of other types of litigation. And you're better off to be in a position of knowing rather than trying to plead ignorance and look like the good guy. So under those circumstances, you should know on the front end if you're getting good legal advice. And if you get the letter from the employer, you've hired this person knowing that they have a non-compete, hopefully you've got that non-compete reviewed to determine whether it's enforceable or not. If it's not enforceable, you send the nasty letter back saying, go pound sand. If it is enforceable, that's when you probably need to call an employment attorney to start figuring out, how do I make sure to limit my exposure on this, because there is pretty significant potential liability. One thing that happens a lot in these spaces, so there are industries that non-competes are everywhere. I can't be too specific without revealing some confidences, but there are industries where the primary people that do the work for the business are covered by a non-compete, and the players in those industries know how to navigate those kinds of conversations. One of the things that some employers will do, especially when these are highly skilled, highly trained people that are very difficult to replace otherwise, is they'll enter into buyout negotiations. And you have to be very adept at planning what's your labor cost on this, because effectively one of the strategies is to negotiate a buyout for this person, and in addition to that, you tie the employee in with your own non-compete, with your own buyout provision, so that you get paid when they leave. And then you may also be in a situation where if they leave within a particular period of time, say 2 years, they have to pay you back whatever portion of the buyout was, or on some kind of graduated level. And that negotiation, it's not very artful. It's just, here's the price, pay it most of the time.
Yeah, that makes sense to me.
So
Right. I mean, that would be a logical thing to do. In that example I brought you earlier with Tesla and Apple, that's what's going down for key personnel who are making the news.
yeah.
But I guess the calculation is you pay up front what your defense costs would be in the alternative, essentially, or that's what you're weighing in the balance is.
Right.
I think maybe I think maybe one thing that's important to know here is that the TRO order that an employer would get would include a direction that the employee sees all competitive activities, which means that the employer that's now hired them away is restricted from continuing to employ that person. So they automatically are going to lose their job. And under those circumstances, it's not just a money and calculus decision. It's how disruptive is this going to be if I try to bring this person in knowing they have a non-compete, and suddenly our operations could be upside down because we have a court order to stop doing what we're doing. That could be a major problem.
Yeah.
In the immortal words of Rodney King, why can't we just all get along? As I think about what we've been talking about today, it kind of brings into context what we were talking about in the last podcast with John, which is the heightened, or the protective nature that this new statute has towards employees, because it's clear, from this conversation today that this could be devastating to individuals if they aren't protected at some level. If they don't have the negotiating or bargaining power to protect themselves, they could find themselves having to move out of an industry they've spent their life training to be productive in.
Yeah, read what you are going to sign and make sure that what you are having other people sign is compliant. From an employment litigation defense perspective, the best advice I can give to employers is if you can look reasonable, we can win the case. If we can't make you look reasonable, we can't win the case. And the truth is if you have a non-compete that bars someone from basically earning a living for 10 years or something, and the one thing that they can do that's been making them money, you look like a complete jerk. So I think on some level maybe there's an effort here to dissuade people from using non-competes, to foster more competition. I think maybe some of the concerns that you're raising about, I'm not going to show you the secret sauce because I'm not sure if my non-competes in order may stifle innovation. I think there's some, I believe that on some level as well.
Yeah, and I suspect that jury trials are waived in nearly every one of these situations.
Yes, so you would want to waive a jury trial, right, from the employer's perspective.
Right.
Very often you do arbitration.
Oh, good point.
I've seen a lot of employers move away from arbitration, and frankly, I'm not a huge fan of arbitration. One thing that's important about arbitration is you can't get injunctive relief through an arbiter. Mm-hmm. Only injunctive relief can be issued through a court. So you may end up in court trying to prove your case publicly anyhow if you're trying to get a TRO. So, and arbitration can be expensive. And I've had great arbiters. I've had some arbiters that missed the mark, and I've had more often experiences where the arbiters just doesn't want to pick a side, and you get nothing.
And that doesn't help at all.
Yeah, that doesn't help anybody.
They were once attorneys who worked 1 hour a week. That was an industry thing. Sorry.
I kind of want to be one of those people only working 1 hour a week, so sign me up.
Yeah, there you go.
I have a non-compete with my own company,
mediator.
though. It might be a real problem for me to go work for those law firms. John, this is great. Any closing thoughts for us?
No, I really enjoyed talking about these issues. I think they're important to understand kind of what the legislature is doing with these important things, especially when you're trying to manage high-level employees and protecting your business. So I'm happy to help in any way I can.
Very good. It's a huge deal for professional services.
Absolutely. Thanks, John.
You're welcome.
Create a beautiful day. Thank you for joining us today. Hope you enjoyed the information we shared.
If you enjoyed this podcast, please feel free to share it with someone else. And join us next time.
If you want to meet with a member of the team, please contact us at info@expertnetworkteam.com. That's info@expertnetworkteam.com.
If you have special topics you'd like to hear about, please reach out to us and let us know at the same email address. Again, that's info@expertnetworkteam.com. Thank you for joining us and have a great day. Thank you for listening to this podcast. We want to remind you that listening to this podcast does not establish a client-professional relationship with any of the firms represented, nor does it constitute legal, investment, or accounting advice, and the views are those of the professionals only.
Investment advisory services may be provided through A&I Financial Services, and securities may be provided through A&I Wealth Management.